I'm Dan Curtis with GilaValleyCentral.net and KJIK.FM, visiting today with Judge Michael Peterson. Now, you had mentioned kind of a new system, I think, of establishing paternity and parental rights. Tell us a little bit about what that is and how it came to be and where you're going with it.
More recently, it is becoming common that a couple will not marry before they have a child together. It is also common that that relationship will fragment or will come to an end. As a result, there are times where one of the parents comes to the court and requests the establishment of paternity and a responsibility to pay child support. Legally speaking, that's all that the state of Arizona does. And our feeling from the court staff and from all of the research that I have ever seen in my own personal experience as a mediator for many years has been that if we can provide an incentive for mother and father to be able to work out a realistic parenting time schedule and a legal decision-making order for the parents, that permits them the opportunity, to the extent that they are able, to spend time with the child and to be able to teach the child and to rear that child in a way that the child is able to have a productive and positive relationship with both mother and father. It's possible, if not probable, that mother and father aren't best of friends. But the benefit to that child when they have a healthy relationship with the mother and with the father has been significant. And so every study with which I am familiar tells me, and my own personal experience tells me, that if we can accomplish that, we've done something very positive for the benefit of a child. And I think that that's something that's very meaningful and important. Historically, for years and years, the way family disputes have been resolved is you come into a courtroom, and that courtroom is full of usually family and friends, and then there are things that are said which are often very acrimonious, very difficult sometimes for people to forget and to move on, and consequently a lot of the wounds that are open in a court never heal. And so the perspective that we have, and this is both Judge Sanders and myself feel very strongly, is if we can have the opportunity for a family to come in. They may not be a family in a traditional sense, but if there's a mother and a father and they share one or more children, they're a family in my eyes, right. And legally speaking, they are as well. To permit them the opportunity to rationally and privately discuss the issues that are obstructing a smoother or better relationship has been very rewarding. Before I became the judge, I mediated approximately 350 family cases successfully. And so that process sometimes is difficult. It often requires a great deal of give and take on the part of the parents. But with the expertise of someone who's been there many times, we're able to help people to be able to come to an agreement where their child or children have the opportunity to have a meaningful and a positive continuing relationship with the other parent. And parental alienation is something that's very destructive to a child. And so this is a process that enables us to be able to try to reduce that. And so that's been something that we found great success with and a great deal of satisfaction. Most people aren't aware that you can do this for the simple fact that it hasn't been done for many, many years this way. It's only more recently that some of the benefits to mediation have been seen by courts and by people that have gone through family court. So we're very excited, and we've seen a lot of success with it so far, and we'll continue doing it.
So they don't need an attorney. Both
Correct.
sides don't need an attorney. They just need to go to the clerk's office and set this up, file some papers and for mediation, right? And then
that is correct. In connection with an establishment for paternity, often the Attorney General's office will initiate that process. By law, they only initiate the establishment of paternity and then the initiation of a child support amount. And so that's only one half of the problem. Financial support is important and it should be ordered. Certainly something I agree with strongly. However, it doesn't take into account the fact that there is also a need to address parenting time, and that's not something that legally is done in the context of a child support case. And so that is an extra step that we're providing and an extra service to parents. If parents are willing of their own accord at that child support hearing to have a mediation, they'll actually do the hearing with one judge, and then the other judge is available literally at the drop of a hat to meet with the couple and to be able to try and implement a parenting time order that they agree to. But the idea is that people are able to come to the court and they're able to get everything done at once. It's very beneficial for that person or that couple to be able to do that because it saves them time, it saves them money. Very few people that I know like going to court, and so as a result, it saves a lot of acrimony and frustration as well. The clerk of the court has been gracious enough, if the people are able to come to an agreement, they actually will waive the filing fee. And so that will save people several $100s as well, to be able to do it in one shot, so to speak. And so we want to be as user-friendly to our people as possible. And if people can come to court one day and essentially get it wrapped up in a day, that's very unusual in other counties, but something that we can do. I've done in other counties as a private mediator before becoming the judge, and I know it can be done because I've done it hundreds of times helping couples out.
Great. That sounds like a really great program. Stay tuned. We're going to have another segment coming up.